Hello everyone, welcome to the channel. So today we are going to start the next chapter in the series of Polity through MCQ series, and these MCQs are straight away based on the book M. Laxmikanth. Now before starting this chapter, let me tell you that just watch this video for 5 to 7 minutes and you will get to know the utility. First of all, I will give you the important explanation which is taken straight away from the Laxmikanth. We will revise the things and then straight away we will solve the MCQs. What will happen is all of your understanding regarding the powers of the High Court and everything that is mentioned in the Laxmikanth book will be crystal clear. So it's a request that just watch this video for 5 to 7 minutes. Now let us start. Now the Constitution of India envisage a integrated judiciary system. What does this integrated judiciary means? It means that there is Supreme Court, which is the ultimate interpreter of the Constitution. But beneath the Supreme Courts, there are High Courts. Presently, there are 25 High Courts. Okay. Now we are going to study about the High Courts in this chapter. Now, the institution of High Court originated in the year 1862, when the High Courts of Calcutta, Bombay, and Madras were set up. Now, again in the year 1866, 4 more High Courts were established. Now, regarding these High Courts, 7th Amendment Act of 1956 is really important. What did this Amendment Act did? It ultimately authorized the Parliament to establish a common High Court for 2 or more states or 2 or more UTs. For example, we see Punjab and Haryana High Court. So Punjab and Haryana High Court is the combined High Court of Punjab as well as Haryana. Okay. So now you need to know this 7th Amendment Act authorizes the Parliament to establish High Court for 2 or more states or 2 or more union territory. Okay. Now let us see the High Court. If we talk about the provisions in the Constitution, this is mentioned under Part 6 of the Constitution, ranging from Article 214 to Article 231. Now, let us talk about the organization of the High Court. Now, every High Court consists of a Chief Justice, which are appointed by the President. Now, this means that the Constitution does not specify the strength of the High Court, and it is up to the discretion of the President to determine the number of the strength or the number of the judges in the High Court. Okay. Now, the President from time to time determines the determines the number of members of the number of judges in the High Court depending upon the workload. Okay. So this is an important fact you need to know. Now, what about the appointment regarding judges? Now, the appointment of the judges of the High Court are appointed by the President. This I think you will know. Then the Chief Justice is appointed by the President. The Chief Justice of India is appointed by the President after consultation. Just a second. The Chief Justice of the High Court is appointed by the President after that consulting the Chief Justice of India and Governor of that state. Okay. Now, the other judges of High Court are appointed by the President by consulting the Chief Justice of High Court. Okay. Now, there is a system of collegium. As you know, I have told in the Supreme Court chapter that there is a system of collegium which decides on the transfer of the judges of the High Court. It consists of Chief Justice of India plus 2 other judges. Okay. Now, this collegium system is a judicial pronouncement and it is not under the Constitution of India. Okay. So this need to know about the appointments. What about the qualifications of the judges of the High Court? First of all, the judge should be a citizen of India, and he should have, the second condition is that he should have held the judicial office in the territory for 10 years or he should have been advocate for 10 years. Okay. Now, minimum age is not prescribed by the Constitution of India. This you need to remember. Now, what about the oath and affirmation? The oath of the judges of the High Court is administered by the governor of that state. What about the tenure? So, the tenure has not been fixed by the constitution and he holds the office until the age of 62 years. Now, one important thing to remember here is the prescribed age for the judge of Supreme Court is 65 years, whereas that of High Court is 62 years. Okay. Now, he can be removed from his office by the president on the recommendation of parliament. Okay, and this is not a constitutional process. This is mentioned, the provisions are given under the Judges Inquiry Act of 1968. Now let us see the process of the removal of the judges of High Court. Now the judges of the High Court can be removed by the president when it is recommended by the parliament. Also, there is to be a resolution that is to be needed to be passed by the special majority of the parliament. What is special majority? So it is the majority of the total member of the house and majority of the 2/3 members of the house present and voting. Okay, two grounds of removal have been mentioned. So those two grounds are misbehavior and incapacity. Okay. Now, the method of removal is mentioned under the Judges Inquiry Act of 1968, and this Judges Inquiry Act I have already mentioned when I was teaching you the chapter of Supreme Court. So, first of all, a removal process is firstly to be signed by 100 members in case of Lok Sabha and 50 members in case of Rajya Sabha. When a resolution regarding the removal is passed, then the speaker, and it is up to the speaker as well as the chairman to decide where to accept that motion or not. So if it is accepted, then there is a special committee that is constituted, which is a 3-member committee that is headed by a Chief Justice or the judges of the Supreme Court. Secondly, there should be a Chief Justice of High Court in that committee, and thirdly, there should be a distinguished jurist. So the special committee, the committee that is formed to look up at the charges, if they pronounce that yes, the charges are true, then a special majority is needed to be passed by both the houses, and then the judges of the Supreme Court and the High Court shall stand impeached. Okay. Now next thing is about the salary and allowances. Now if I talk about the salary, so the salaries of the judges of the High Court is determined by the parliament, and one thing important to be noted here is that the salaries of the judges of the High Court is charged on the consolidated fund of the state government. Okay, but the pension of the judges of High Court is charged on the consolidated fund of India. This important difference you need to know, you need to remember this. Now what about the transfer of the judges? So the president can transfer a judge from one High Court to another by consulting the Chief Justice of India, and this Chief Justice of India further consults the collegium. I already told you, the Chief Justice of India, the advice of Chief Justice of India is not sole here. He has to consult the collegium, and whatever decision the collegium takes, then the presidents transfer the judge. Now what about the acting Chief Justice? The president appoints the acting Chief Justice of the High Court whenever the office of the Chief Justice is vacant, or whenever the Chief Justice is temporarily absent, then the president can appoint the acting Chief Justice. Now what about additional and acting judge? So the president can appoint duly qualified person as the additional judge for a temporary period not exceeding 2 years. So the maximum tenure for which the additional and acting judges can be appointed is of 2 years. Okay. Now what about the retired judges? Yes, the retired judges can become the judge of the High Court, okay, on the request of the Chief Justice of that High Court. The retired judge can act as the judge of High Court when the Chief Justice of that High Court requests them to, but previous consent of the president is needed in this. Okay, previous consent of president is needed. Now let us see What about the independence of the High Court? So the mode of appointment, as the judges of High Court are appointed by the President in consultation with the judiciary itself. So this affirms this mode of appointment, upholds the independence of High Court. Now, what about the security of tenure? A High Court judge is provided with the security of tenure. He can be removed from his office only by the President, and that too when a resolution is passed by the Parliament. Next is the fixed service condition. All the salaries, oath and affirmation, all the salaries and allowances that are given to the judges of the High Court cannot be diminished during their period. There is only a condition when there is financial emergency operating in the country under Article 360 of the Constitution. Then the salary of the High Court judges can be reduced. The expenses are charged on the consolidated fund. It means that the salary of the judges of the High Court is charged on the consolidated fund of state, whereas on the other hand, if I talk about the pension of the judges of the High Court, it is charged on the consolidated fund of India. The next point is the conduct of judges cannot be discussed in the state legislative assembly, neither the parliament. The conduct of the judges can be discussed. So this also provides a security of tenure. Now, ban on practice after retirement. So the retired permanent judges of High Court are prohibited from pleading or acting in any other court, except the Supreme Court of India. Now, let us see about the jurisdiction and power. Now, what about the original jurisdiction? As we have seen under Article 131, the Supreme Court enjoys original jurisdiction in three matters. The matters which are relating to the Parliament on one side or state on the other side, Parliament plus state on one side plus other states, and state versus states. So these are the three matters in which the Supreme Court of India enjoys original jurisdiction under Article 131. So the High Courts also enjoy original jurisdiction on some matters. So for example, matters relating to marriage, divorce, company law and contempt of court. The matters relating to the elections of members of Parliament and state legislature. Just remember this thing. The High Court enjoys original jurisdiction with disputes relating to the election of members of Parliament as well as the state legislature. Okay. Also, the High Court enjoys original jurisdiction regarding revenue matters or act ordered in done of collecting revenues, enforcement of fundamental rights. Now, if I talk about the fundamental rights, you need to know that the writ jurisdiction of the High Court is wider than that of the Supreme Court. This I will tell you in some time. Okay? So these are the matters under which the original jurisdiction of the High Court is exercised. Now, what about the writ jurisdiction? Under Article 226, the High Court can issue 5 writs, that is quo warranto, habeas corpus, mandamus, certiorari, prohibition and quo warranto. Okay? These are the 5 writs that can be issued by the High Court. Now, the important thing here to note is, although the Supreme Court is the highest level of judiciary in the body, highest level of judiciary body in our country, although the writ jurisdiction of Supreme Court is not that or not like that of what High Court has. It means that the High Court writ jurisdiction is wider than that of the Supreme Court. Why is it so? Because the Supreme Court can issue writs only for the purpose of enforcement of fundamental rights. On the other hand, the Supreme Court can issue writ for the enforcement of fundamental right as well as any other reasons. Okay, so that is why the writ jurisdiction of High Court is wider than that of a Supreme Court. Now, the appellate jurisdiction, as the High Court is the primary court of appeal, so both civil and criminal matters there is appellate jurisdiction that lies with this High Court. Okay. Also, you need to know that the appellate jurisdiction of High Court is wider than that of the original jurisdiction which we have studied here. Okay, control over subordinate court. Now, the governor discusses the judges of the High Court, of the Chief Justice of the High Court, before appointing the before appointing, posting and transfer or promotion of the district judge. Okay, so there is subsequent amount of control that High Court has on the subordinate courts. Now, the power of a judicial review. Yes, the power of the judicial review, although the word judicial review is nowhere mentioned in the Constitution, but as per Article 13 and 226 of the Constitution, the judicial review, the power of the judicial review is there with the High Court. Now, the High Court has power under the High Court under judicial review has power to examine the constitutional validity of legislative enactments of the state as well as the executive orders of both center as well as state government. Okay, so this is all regarding the power of judicial review. Now we are done with the important facts, the important explanation of this chapter. Now straight away we will move to the questions and then our chapter will be complete. Now let's start the questions itself. The first question is, the maximum number of judges in a high court are specified in the Constitution. Now during the explanation part, I have already told you that the maximum number of judges of high court are not specified. These are decided by the president, and it is on the discretion of the president who may decide the number of judges in the high court depending upon the workload. This I already told you. Okay, so the first statement is absolutely incorrect here. Now the second statement is, every high court has power of superintendence over all courts and tribunals except military tribunal, provided they are subject to appellate jurisdiction of the high court. Yes, every high court has a power of superintendence but not of the military tribunal. So first statement is wrong, second is correct. So only second is the correct answer. Let's see the next question. The next question is about, a high court has jurisdiction to punish for the contempt. Yes, as we have seen in the Contempt Act that the Supreme Court as well as High Court has power to punish for its contempt, and this contempt can be both civil as well as it can be criminal. So the first statement is absolutely correct. Now the tender advice on legal question referred to it by the President of India. Now I already told you in the advisory jurisdiction of the Supreme Court under Article 143 that the President may take advice from the Supreme Court of India and not the High Court. So the second statement here is absolutely wrong. Straight away we will come to the answer, that is 1 and 4. But let us see the other options as well. Now what does option 3 says? That to tender advice on a legal question referred to it by the governor of the state. No advice is taken by the governor from the High Court. Legal advice, legal question पे no advice is taken. Okay, although advisory jurisdiction में एक केस होता है जहाँ पे the governor ask the chief justice of the High Court regarding the appointment, promotion, etc. of the judges of the subordinate court. Okay, but not on a legal question. So 3 is also wrong. Now the fourth point is, issue certain writ for enforcement of the fundamental right or for other purposes. Yes, the enforcement of writs under Article 2 to 6 of the High Court, it gives it the High Court right to issue writs for the enforcement of fundamental rights. But also you need to know that the jurisdiction or the jurisdiction of writ of the High Court is wider than that of the Supreme Court, because the High Court can issue writ for the purpose of fundamental right plus as well as any other reasons. Okay, so if I talk about the correct answer here, 1 and 4 is correct. Let's now move to the next question, that is question number 3. The transfer of judge from one high court to another high court may be made by the, now I already told you this transfer of judges is made by the president, and he consults the Chief Justice of India, who in return specifies or advocates the decision that is taken by the Collegium of Judges. So let us see which of the following options justify our explanation, which we have read in the explanation part. Now let us see. The President of India in consultation with the Chief Justice of that High Court, no. There is a role of Chief Justice of India of the Supreme Court, not the High Court. Okay. The Chief Justice of the concerned High Court, no. Governor, no. Governor does not has a role to play. Although the appointment of Chief Justice of High Court The President appoints the Chief Justice of High Court by consulting the Chief Justice of India as well as the Governor of that state. Okay. Option D is President of India after consultation with the Chief Justice of India. Yes, this is true. The D option is absolutely correct here. So D will be our correct answer. Now next is, a retired judge of a high court cannot practice in the Supreme Court, practice in any high court, practice in the high court from where he belongs. Yes, the statement is absolutely true. A retired judge can be appointed by the Chief Justice of India prior to consulting to the President. Okay. Next is question number 5. The writ jurisdiction of Supreme Court of India under Article 32 of the Constitution of India is not wider than that of the writ jurisdiction of the High Court under Article 2 to 6, because the High Court may exercise this power in relation to, I told you, any other rights, any other purpose के लिए भी the writs can be issued by the High Court under Article 2 to 6. Okay, fundamental rights as well as any other legal rights. So B is the correct answer. Now let's see question number 6, which is, who among the following extends the jurisdiction of a high court to or exclude from any union territory? So when I was telling you about the 7th Amendment Act of 1956, I already told you that there is power with the Parliament to make a high court for 2 or more states or 2 or more union territories. So the power regarding the jurisdiction of the high court resides with the Parliament. Okay, the Parliament may by law extend the jurisdiction, but if the question is asked about the strength of the high court, then it is up to the President who decides, depending upon the workload on that high court. Okay, so the correct answer to this question is A. Let's move to the next question. Now, the nature of consultation with the Chief Justice of India in the matters of appointment of a judge of High Court is correctly described as inspection of the file. By it is not inspection, but when the third judge's case pronounced the system of collegium, then this suggestion was termed as conformity. This consultation was termed as conformity. So it is conformity with the opinion of the Chief Justice of India. This is a legal term. You need not go to the depth, so much depth in this statement, but you need to know that this consultation is not just merely a consultation, but conformity with the opinion of the Chief Justice. So C is correct here. Let's now move to the next question. A habeas corpus writ petition dismissed by the Supreme Court can be admitted by the High Court under Article 2 to 6 of the Constitution. Now, I already told you there is a system of integrated judiciary. So, a person may not necessarily go to Supreme Court first, but he may go to the High Court first for his implementation of the fundamental rights. Okay? Then again, if the judgment is not in favor of the applicant from the High Court, then he can move to the ultimate interpreter of the Constitution, that is the Supreme Court of our country. So if the High Court decision is not in favor, then he can go to the Supreme Court. But we have seen under Article 141 of the Constitution that the decision of the Supreme Court is final and binding on all the courts that are there in our country, may it be high courts or may it be subordinate courts. Okay, so the decision of the Supreme Court under Article 141 says that the decision is binding on all the other courts of the country. Okay, so if a writ petition is dismissed by the Supreme Court, it cannot be admitted to the High Court under Article 2 to 6 because the Supreme Court is the ultimate interpreter. So the assertion is absolutely incorrect. Let us now see the reason. In exercising writ jurisdiction, the power of Supreme Court and High Court are concurrent. Yes, both can issue writs under Article 2 to 6, which is related to the High Court, and Supreme Court can issue it under Article 32. Okay, so A is false here, but the reason is true. Let's now move to the next question, which is, which of the following is not correct? The Supreme Court can overrule itself. A High Court can overrule itself. The judgment of Supreme Court binds the lower court. All of this is correct. ठीक है, we have seen in the court of record under article 129 of the Supreme Court, we have seen that the Supreme Court acts as a court of record. It means that the Supreme Court can reverse its earlier decision. So for example, in Golaknath case of 1960, the Supreme Court asserted that the DPSP for the implementation of DPSP under article for the implementation of DPSP, the fundamental rights can be done away with. But the Supreme Court reversed its judgment in the Keshwanandan Bharti case. So the Supreme Court can overrule itself. A High Court can also overrule itself, because a High Court is also a court of record. Okay. The judgment of the Supreme Court is binding on all courts. This is Article 141. And the judgment of High Court do not bind the lower court. The statement is absolutely incorrect. The High Court of the state have a sole control over the lower courts of the state, and the decision of the High Court is binding. Okay, so the statement is not correct. The question is asking about the not correct statement, so D is the not correct statement here. Let us see. The High Court having jurisdiction in judicial matter relating to the largest number of union territories and state. So which of the following states have High Court have the largest number of state and UTs? Now I already told you this was done by the 7th Amendment Act of 1956. There can be more than one. There can be a High Court, common High Court for more than one of the states or union territories. So the Guwahati High Court. This is a kind of factual question. So the Guwahati High Court has the largest number of states and union territories under its control. Let's now see question number 11. A judge of a High Court can be removed during his tenure by. Now I already told you there is a Judges Inquiry Act of 1968. The High Court judge can be removed by the President on the recommendation of the Parliament, and the process is defined in the Judges Inquiry Act. So let us see which option suits here correctly. So the governor does not remove. The President on the basis of resolution passed by the Parliament by 2/3 majority. Yes, this is the special majority. So which of the following options seems to be correct? So this option B is absolutely correct. Now let us see the next question. The power of judicial review means the power of the court to define and interpret constitution? No. The power of the courts to declare null and void any legislation or executive act which is against the provision of the constitution? Yes, the statement B is absolutely correct. Also, you need to know that this judicial review is nowhere mentioned under the Constitution of India. Okay, and this power of judicial review has been given to High Court as well as Supreme Court under Article 13, which defines what amounts to law under the Constitution, and Article 2 to 6, which is related to the writ jurisdiction of the High Court. So the power of judicial review has the power to declare null and void any legislative or executive act of the state as well as the center. Okay, so B is the most correct explanation here given to this question. Next is question number 13. Under the provision of the Constitution of India, who is entitled to be consulted by the President of India in the matters of appointment of the judges of the High Court? Now I already told you, the President of India appoints the judges of the High Court by consulting the Chief Justice of India as well as the governor of that state. Okay, D is the correct answer here. Now question number 14, let's see. Under which articles of the Constitution the power to issue writs for the enforcement of fundamental rights are vested in the Supreme Court and High Court? This is a pretty easy question, and this is very important question as well. So the power to issue writs for Supreme Court applies under Article 32, and for the High Courts it is given under Article 2 to 6. So both of these statements are correct. Next is, which of the following are the main jurisdiction of a High Court of a state? So is there original jurisdiction? I have already told you, yes, there is power of the original jurisdiction which lies with the High Court. On which matters? First of all, matters relating to marriage, divorce, company law. Then secondly, elections of the members of the Parliament as well as the state legislature. What was the third point in the original jurisdiction? So any matters related to the revenue collections. Next is the fundamental rights of the citizens. All this is contained in the original jurisdiction. Now, next is supervisory jurisdiction. Yes, there is supervisory jurisdiction. How? That the High Court has power of superintendence over all courts of the country as well as tribunals. But this does not include the military tribunals. Okay, so the High Court has supervisory jurisdiction in this. Or High Court also has appellate jurisdiction in civil matters as well as criminal matters. Now the next point is advisory jurisdiction. Have we studied this advisory jurisdiction? No. This advisory jurisdiction lies with the Supreme Court under Article 143, where there are two cases in which the Supreme Court is tendered to give advice to the president. Now the first is on the matters of pre-constitutional treaty, agreement, convention, etc. And second is the matter of urgent public importance. So in the first case, it is obligatory for the Supreme Court to give advice to the president. Okay, so the advisory jurisdiction under Article 143 lies with the Supreme Court and not the High Court. So straight away we will eliminate this fourth and directly come to the answer, that is 1, 2 and 3. Now with this question we have finished this chapter of High Court. I hope I hope that I have made things clear to you. So if you love this lecture, do give it a like. Comment section में mention करना how was this lecture, and thank you for watching.